Quick motion hearing for the YNW Melly murder trial today. The defense and the prosecution argued whether or not the jury should see the vehicle that the murders occurred in. And then a little bit of an issue happened with the deposition of Trayvon Glass, which is one of the kids that was in the red vehicle. He apparently has charges pending in a new case that happened in the last month, and his lawyer wasn't present during the deposition, so they had to stop the deposition, but then the judge orders for them to continue later on. So it gets pretty interesting towards the end there. Let's get right into this video. All right, here. Oh, Melly's in handcuffs today. In his suit. So there's just some motion hearing today. Sits down, smiling, sitting over where the jury usually sits. There's no jury today, obviously.
We started the deposition of Trayvon Glass this morning, criminal record, and found that he has a pending charge and that he has a lawyer.
Trayvon Glass has a pending charge, and they discovered this morning when they were doing his deposition.
They wanted to speak to him because his client was being deposed, and no one gave her notice about the deposition because he may have a Fifth Amendment privilege dealing with some of the questions. He said he did not. I asked the state if they contacted his lawyer and was advised they did not, that we cannot give him legal advice. Immediately stop the deposition. Here we are in front of you.
There is no discoverable information that could come from the pending charge other than whether or not any promises or anything have been made.
We do plan on asking questions because we believe one of the crimes deals with moral turpitude.
Melly's team is basically saying that Trayvon Glass should have had his lawyer at the deposition, and apparently the state didn't notify his lawyer.
It's an obstruction of justice, and it doesn't matter if it's a misdemeanor or a felon. And under the discovery rules, we have a right to inquire about anything. So when they say it's only resisting arrest, that's what they told us yesterday, but that we have found out that is absolutely incorrect.
This is a witness that was previously uncooperative, failed to comply. We did a random search about 2 weeks ago, found that he had been arrested. The information was filed on June 19th of 2023.
I'm seeking to postpone this deposition so that he can have his attorney present. He's a young man, and for him to decide what questions may or may not incriminate him, with all due respect, it is foolish to believe he knows that and the ramifications. And I cannot, nor can the state, advise him of this. What they should have done, with all due respect, if they contacted him since we've been waiting, is have him on standby and listen to the depo. And I think it's negligent on part of the state not to notify his lawyer until we're starting the depo. For the state to come in here and say he can invoke his right anytime he feels like it. That's why you have a lawyer.
Public defender, his jurisdiction is solely in Vero County Beach.
Individually raise the right to a lawyer all the time.
I think the Florida bar rules provide that when you know that someone is being represented.
Now they're arguing about the jury seeing the vehicle where the murders happen in, and this is a really big deal because the jury physically seeing this car could impact a lot of them. I mean, imagine seeing a car that you know 2 people died in.
Arrangements for the jurors to be able to view the item of evidence.
But as I set forth in my motion, I believe it's overkill. The witness testified to the specs, the measurements in the car. We actually have photographs that have been moved into evidence that have measuring sticks that clearly show you the distance in the car. We don't even know where the decedents were truly sitting because there are no crime scene photos that actually show them being in the car at the hospital. And argue the proposition of what she's trying to say, this person sitting here and this person sitting here. There's no actual evidence that that's how they were sitting. And I'd also argue it's a biohazard.
Argue it's a biohazard?
Then you make my point. We have enough pictures that have been moved in. Which much of the theme of this case is overkill. It's redundant. They don't need to see the car to get the understanding of the size of the car. I think we got that with the measurements.
I respect the motion tonight. I don't think it's necessary to have a jury view. I don't think it's essential. We both have the photographs of the vehicle in question. I don't think it's going to assist the jury to any great degree analyzing the evidence. So, respectfully, motion tonight.
Ooh, he sided with the fucking defense. He said motion denied. The jury is not going to see the car. That's kind of a W right there for Melly's team. Like, bit sketchy for this jury to see this car, dude. I believe they're talking about experts that the defense are going to bring in right now.
Very unscientific, as he admits, testing that he has done in this case. So I'd be asking those to be turned over forthwith.
So it's about the cell phone records. The state just called it unscientific.
Well, none of it's celebrated. It was based off data from the health app. I thought it would behoove us to get somebody to actually test it. We did start his deposition.
Can I stop you for a
Yes.
second? So, this expert, his name is Larry Daniel, correct?
Yes.
He's going to testify as to the health act?
Yes.
The health app. Oh, I think they're trying to fight the footsteps that Melly apparently did with his phone, where he walked 1,300 steps to the woods after he got out of the car.
I know the state attorney did get in for almost 2 hours other areas that we were not planning on introducing him to, but yes, if we want an order limiting his testimony to only the health app, that's sufficient with us.
Expertise opinions on the health act, correct? That's what we're talking about.
The witness himself said it was an unscientific testing that he was doing.
Oh, he said himself it was unscientific.
Steps taken and the time frame in which those steps are taken, as well as the GPS distance for those steps that are on there. That is coming from Celebrate, not from the phone Apple Health app as you look at it on the phone itself. The witness was trying to do is he just took 2 phones and put them in his pocket and walked around his house for a day. There is no validation. He didn't count the number.
Bro put phones in his pocket and walked around his house. That's what the defense is bringing in.
He is an expert in this field. He is doing testing on it. However, it's to counter her introduction, the state's introduction of this evidence.
That it's limited to this health app, and so that's a short order.
Which is we interposed an objection to the admission of this evidence. There's been reference to an out-of-state case regarding the admission of Fitbit. This one is not Fitbit. And in order to introduce information derived from phone application technology, such as GPS, and in this case, a pedometer, that there must be a witness to authenticate it as far as its reliability is concerned. Out-of-state case, with all due respect, missed the mark entirely. They said Fitbit's around for a long time. We don't have to explain to a jury what Fitbit is. They understand what it is, and they believe it's reliable. If a jury believes something is reliable, it's of no moment. The reliability has to be established. And we have been, because trial is a fluid process, presenting the court with case law as we go along. This motion would not, I guess, be ripe until the depo has been concluded. So
Melly's team is basically now arguing over how reliable the technology behind the health app and how it tracks your footsteps.
It doesn't have to be.
It
It doesn't have to be. They know that he's got pending criminal charges. They know he has a lawyer. Discovery rules for deposition are pretty open as to what we may ask that may lead to relevant information. And under the rules, that's why we stopped once we learned that he was represented and that he had no contact with his lawyer.
It basically indicates that they're allowed to do it if he exercises his Fifth Amendment right.
Okay, so you're saying, so it's clear we're not violating any rule, even though we know that he is presently being represented by counsel.
I don't, counsel, I'm looking at the state case of Levy State. It's an older case. It says, I understand what you're saying about 4-4.2. I don't know what the circumstances of that are. That is not as clear to me. My thought is the deposition should proceed.
Pursuant to your ruling, we will proceed. I actually wanted to protect ourselves and not violating the rule. I don't think that's material because it deals with his credibility as he takes this stand Monday.
You can ask him anything you want about whether there's any charges, deals that are made, anything that goes to bias.
I understand.
They just said Trayvon Glass is taking the stand on Monday. Oh shit. We're about to see that on Monday, boys. But apparently the judge sided with the prosecutor that they're going to keep on going with the deposition of this kid without his lawyer present, I think. Melly's team got a W with the jury not being able to see the vehicle in person because that would have been pretty impactful for sure to see the vehicle in person, but I guess not. That's pretty much it for this motion hearing. Kind of wild to see Melly in handcuffs right here as well. What's he saying to the police officer, dude? It's so weird to see him in handcuffs. We haven't seen him in handcuffs at all for the trial, so that's it for this video. I'll keep covering the trial come Monday. Subscribe right now. Follow me on Twitter and Instagram and Threads. Peace out, boys.